Okay, we're going to call the meeting to order. So this is the Procedural Subcommittee for the Eberhardt v. MOA assessment issue.
And you can just hit stop or take it off record if you want.
When we're done?
Yeah, if you go into executive session,
Mhm.
if you want to record it, you do need to hit stop and then hit record again.
And say
if
we're in executive session.
you record the executive session. That way it's on a different file
Okay.
and we
When
can
we
make
come out,
sure
we
to.
have to decide when the executive session can be released.
Okay, we'll do that. And so just for the record, I'm Amy Domboski.
Yes, I do.
Joe Levesque.
Big Training Assembly.
Julia Tucker, Assembly Counsel.
Bill Evans, Assembly.
All right, so Mr. Levesque, we're going to let you start, if you will.
Very well. So Joe Levesque here. I'm special counsel to the Assembly in this appeal. And things are a little convoluted, and I'm going to summarize a little bit some of the things that have happened and where we are in this matter. And I should mention that under the Cool Homes case, which is a case out of Fairbanks, there's a footnote, I believe, that the Alaska Supreme Court has that says that when you have an attorney and the attorney is just summarizing things that are public record, that's not privileged or confidential. And so I intend to just summarize what is public knowledge. And then if for some reason you have questions and want to go into executive session, then we can deal with that at that time. But for right now, that's not an issue as far as I'm concerned. So as you all know, I was appointed as the second special counsel. Cheryl Brooking was the first, and then she left her private attorney work and went to work for the state. And so I was subsequently appointed. What you have is a number of lot owners in Turnagain who have had significant amounts of water work, sewer work, and lift stations all put into their neighborhood. And under the municipal ordinances, a special assessment will now be calculated, determined, and then apportioned to each lot owner. And so when this first began, these lot owners apparently hired an attorney, and that's Mike Staley. And they said, Mike, we think these numbers are too high, whatever they said. So he started looking into it. And as the assessment was brought to the Assembly, he, as an attorney on behalf of his clients, was asking for a lot of information, the records that would basically substantiate the assessment and all the calculations and the bidding documents, who did the construction, the whole thing. They were concerned about the lift station and the lift station being something that was assessed to them, whereas they thought maybe that was not proper. They were also concerned that some of the construction may not have actually benefited their lots. And so they had all these different issues. Now, my understanding was that it went properly before the Assembly, and they were before the Assembly asking for all this information, and the information was not forthcoming. And so they may have got the information at the 11th hour, but it certainly wasn't enough for them to prepare. Some of the information they may not have gotten at all. And so the Assembly, acting in its normal course, basically looked at the assessments that were recommended and approved them. And these people felt like they did not have a fair process. And so they appealed, and they appealed to the Superior Court on a number of different issues, and some that are not going to be before us. And I've pointed this out, and I say us, I mean the Assembly. I've pointed this out in some of the emails and the memorandum that have been circulating. There are issues about unjust enrichment and collateral estoppel, and also about bidding process, whether it was proper or if there were irregularities. Those particular issues are going to stay in front of the Superior Court judge because he really has jurisdiction to deal with those kinds of issues. But the other part of the case was that these plaintiffs wanted a de novo trial. So they wanted the judge to basically start over as if nothing had ever happened. Like there's not even a record. We can start anew. And the judge, quite frankly, they don't. The court system doesn't allow trial de novo every time that it's requested. It's something that's a little sacred, and you really have to show that the process isn't fair and you weren't given an opportunity. This judge, looking at the municipal code, said, you know, I don't see any reason why the assembly can't deal with this. They're properly trained, they're the right body. I'm going to remand this old assessment that's being challenged back to the assembly. And so everybody assumed that that's what we had before the Anchorage municipality. An appeal that says, Anchorage Assembly, take a better look. Take a hard look at these assessments. Listen to these people. Allow them to testify and make comments. Let them bring in experts if they choose, whatever, but make a record. Make a complete record that's reviewable by me, the judge. And if you don't do that, then I'm going to entertain doing this de novo. And that completely takes it away from the assembly, and the judge is going to be the trier of facts and the decision maker. And so anyway, lo and behold, last week I went to a court hearing. It was more of a status update on what we call the companion case. It's those issues about the bidding irregularities, unjust enrichment, and equitable estoppel. And walking in there and meeting for the first time Mike Staley and Bob Owens in their relevant roles, I was told by both of them immediately, you have to understand this is not an appeal of an old assessment. The old assessment has been set aside. What we have now is we have a totally new assessment, which my understanding is nobody has seen, at least nobody in this room. It's never been presented to the assembly.
Not that I know of.
And so we're really talking about a new assessment. And the attorney for the plaintiffs, Mike Staley, has indicated something that Julia Tucker and I have talked about. Don't we really have the cart before the horse here? Shouldn't this new assessment now go in front of the assembly, and the assembly do what it normally does? And if the parties aren't happy, then they can appeal that. The judge wants the assembly to hear it on appeal. And we can go forward, build a record that's reviewable, and then all the judge has to do is act as an appellate court, which the judge would prefer to do, rather than open this up into a big trial. So where we're at today is when I talked to the attorneys, both Owens for the municipality and for Staley for the plaintiffs, they advised that they thought the procedures were wrong because this isn't an old assessment, it's a new assessment, and they were going to work on coming together with some things that they agree about the procedures. And I said, hey, please do, because obviously anything that they like and they present and they're happy will limit and narrow any possibility of all these like collateral appeals, these points on appeals that are technical rather than the merits.
So the judge throw out our first assessment on this training group? Because I was on the assembly when we did that. We had testimony on it. So did he set it aside or what?
No, the judge did not set it aside. The judge said, I'm remanding it back to the assembly, and I want the assembly to do this again, only create a better record and allow these people a fairer process, a better process. So that's what happened. Who set it aside, I believe, and I don't have all the facts, but I believe the municipality, when this happened, went to the auditors for the municipality and said, can we just look at this assessment again? And they were going to complete an audit, and they had promised that upon the completion of that audit, it would be released to Mike Staley and his plaintiffs, so his clients, so they could look it all over and decide what the issues are. My understanding is that during that process, there was a decision made by the municipality to set aside that old assessment and to create a new assessment. And as Mike Staley kept asking Bob Owens, well, I still don't have the audit. I really want the audit. I need the audit. Bob Owens says there is no audit. We have no audit. And he says, well, they came out with a new assessment. There must be something. And Bob said, well, there's a lot of notes, and they're hard to read, and the auditors, crunch all that, and I'll be more than happy to give that to you, because that's all there is.
But what I thought that, from your note, I thought that Staley said that he had been given
He'd been
the
given.
new assessment on April 4th.
Correct.
And so I was out of town when we got,
Yeah.
when you went to that meeting. And so is there a new assessment, or is there just this audit with the notes?
No, the audit with the notes had never been released. And Bob Owens said, I'll give those to you, Mike Staley. I don't know if that's happened. What I prefer is anything that's given over, I think, should be run through the clerk's office, so everybody knows what the record is, and we can bait stamp things, and and really create a record that if it goes back to the court, we can say, look, the assembly took a hard view, they listened to everybody, they analyzed the law, and they made a determination.
Can I clarify something, Joe? Originally, there was an assessment done. That assessment, there was going to be an audit, but then I heard you say, somebody said there really wasn't an audit. There were just a lot of notes, but then your comment was there was an audit.
No. My understanding was from meeting with both Bob and Mike. Mike believed there was an audit, and they were just withholding it. Bob said clearly, there never was a final audit.
Okay, so the whole point is there was an assessment, there was a reevaluation of that assessment. The assessment was set aside. Now they have been given a new assessment. So to me, the whole audit is kind of a moot point.
It's a moot point, but Staley, on behalf of his clients and being an attorney who really wants to shake every branch, is saying, look, if you have something that hasn't been turned over to me, I want it.
Sure.
So regardless of whether it's a final audit or it's just notes from an auditor, I want to see it.
Sure, and I would assume whatever that research, I'll call it research, whatever that research was, is what was the basis for developing the new assessment. That would be my guess.
I would assume the same. So then Mike Staley says, well, I do have the new assessment. I was given a box on April 4th, and so I have the new assessment. But we don't know where the new assessment is in terms of the assembly agenda.
The new assessment has not come before us.
I've not seen it. Or if AWWU has it.
I don't know.
So moving forward, procedurally, I mean, we're supposed to have a hearing the 7th and 8th. Obviously, it would be premature.
Well, it could be. What I'd like to do, you've all had a chance to look at Mike Staley's letter where he said, look, there still are all these due process issues, and people are not going to be noticed that are going to be affected and impacted by this, and we really need to kind of stop and make sure that this is done properly. And so he wants more time. Bob Owens told me initially when I was talking to both of them in court that he would oppose a continuance. And I'm not sure if he's changed his opinion, but that email that he sent yesterday saying, well, here, I'm going to outline my basic points, he didn't mention that again. In fact, what he seemed more concerned about was that the ordinance that provides for a 15-day notice may be too short. That Staley might argue that, because of the money involved and because of how it affects these property owners and it's a contentious issue, more notice is required. And we do have case law. There's a case, it's old, I guess, by my standards, 1980. And what it was the Anchorage School District was going to shut down a school. And they had a 5-day notice requirement that they always followed. They gave 5 days notice, and they shut down the school. And so some of the people, the neighborhood people, said, well, this wasn't fair. And the Supreme Court said, we recognize that 5 days is your normal business notice, but for something like this, you need to give more notice, more reasonable notice. And so I think that's what Bob Owens is thinking about, because it was the first point on his email, is that Staley may very well say 15 days notice isn't enough.
You can't even start running the 15 days. The Assembly hasn't even approved the new assessment. And that has to happen
That's
before.
I
right.
haven't seen the new assessment, right.
That's what, that business about what they're calling the new assessment is of concern to me, because the record was supposed to have been with the clerk. It's on disk or something.
Yeah, I have a copy of the record.
Right. And so is what was given to the clerk, does that include this April 4th assessment that was given to Staley?
I don't think so, but I'm going to find out.
I'm missing a piece here somewhere, because last year, I thought, right when I first got on, I thought we had basically reaffirmed the assessment.
That probably would have been the old assessment. I have to look at it, I don't remember.
So, and that's what I'm thinking, and well, I keep hearing about, they don't have proper notice and they don't have all this, but if we did reaffirm it, then what was the time frame when they set aside? Was it recently?
And remember, as we understand it, the court didn't set it aside, it's.
The city.
But some like demonstrations set it aside, which I find odd.
But even if you reaffirm that the court has set, it says that doesn't apply. So we'd have to have it again, even on the old assessment, based on the court order.
Yes.
But the
And
city seems to have set it aside since then.
that's what I understand from talking to those two gentlemen, and that just changed everything. And so, and that's why they're both aligned, as they say, there is no old assessment to appeal, there's a new assessment, and so the
We
procedures that have been adopted by the assembly are really not the right procedures.
Well, who is the person in the administration that A, could set aside the assessment, and then B, actually issue a new assessment?
We need to get our attorney look into it, because I want to find out where the new assessment is. Because that's got to start with AWWU, it's got to be there,
Mhm.
you know? Because I feel like we're kind of blinded going into this. If there's a new assessment, we've not seen it yet.
Right. So, Amy, I just wanted to point out this 15 days notice that we're talking about is
Yes.
the notice of the appeal hearing. And so we were just thinking.
We all concur that it's not an appeal.
Exactly.
That's all parties.
Exactly.
No, I shouldn't say we. All parties seem to concur there is no appeal.
Correct.
And I guess I would look to, in the, part of the training that you witnessed when we had before is to make sure that everything is done in process.
Mhm.
And so to me, it seems to me that the parties need to answer some of these questions, not
Mhm.
Assembly Counsel going and running around finding extraneous stuff
Mhm.
outside the scope of our review here.
Right, so what
So-
I've set up basically is a relationship with both attorneys, where I've told them, acting as special counsel to the assembly, if you're gonna file something, make sure it gets filed with me and with Barbara so she can distribute it. And then, if I have questions, I will contact you both.
Well, I
And-
noticed that Staley wrote you back on the business about the stipulation. You sent out a notice,
Yeah.
a note to both he and Bob Owens, and you said, after our meeting, blah, 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 where's that stipulation? And Staley wrote back and said, I didn't ever say I said I was gonna do a stipulation.
Well, they're playing with words. I mean, he was playing with words because what he said was that, and they were talking after I left, so they may have had, something else in mind. But he says now that, so I wrote my letter, and now Bob's gonna respond to it, and he's gonna basically say what he agrees with and doesn't agree with. And so we don't have Bob's letter, it's gonna come today. And I think that,
So when you said I wrote my letter, is that Staley wrote his letter and Bob is gonna agree, or you wrote a letter
right,
and Bob?
no, this is Staley's letter
Right,
from
right,
yesterday.
right.
Yeah, right, so, Bob Owens is gonna respond to that. And what Staley says was that rather than agreeing to file a joint stipulation, which is what I heard, that Bob is going to respond to this and he's going to basically outline what he agrees with and doesn't agree with, which is the same sort of a thing.
Right,
Because
that's
when-
good, that's movement.
And I said, I don't care, I mean, call it whatever you want, I just want to know what you guys agree on and what you don't. Because that'll make the assembly's job a lot easier.
Well, I think the scope of this committee was to advise the chair as to procedures at the hearing, but I think from what I'm hearing, it sounds like the hearing on the 7th and 8th.
Well, what we're going to do, what I would recommend.
Yeah, I was going to say, how do you recommend we moving forward?
I recommend that we wait until we receive Bob Owens' letter, because he gave us a little outline of what his letter would be, but we haven't seen the letter. And that if he, in the letter, opposes the continuance, then you should consider, that you can, and we can all get back together telephonically or whatever, to discuss what next to do. And what I mean by that is whether or not you would recommend to the chair that this matter be continued or not. And that's how I do it.
Yeah, we'll wait for all the facts to come in before you
Right.
make your decision. Mr.
Yeah.
Trainee?
Madam Chair, could we get the attorney to get with both other attorneys? I want a copy of this new assessment.
Okay.
And if Staples has it, I want to see it.
Okay.
And also to
Yeah,
have it be
I agree.
date stamped. I mean, I think that those things should go through the clerk's office and have.
Mr. Evans?
Yeah, if you'd give it to the clerk's
Yeah, I
office
have
for them to get it.
a little concern about that, because I think that, as I understand everything, and you have this case from this old assessment that went to the Superior Court. The Assembly approved the assessment, the matter went to the Superior Court. The Superior Court says, I'm remanding it back to the Assembly for further due process considerations. That is the case, you have parties in, and it's, discovery is including in that case. If, as a result of that case, the assessment was set aside and the city has revamped that and came up with a new assessment, I don't think that new assessment has anything to do with this case that exists. And Mike Staley and his plaintiffs, and even Mr. Owen at the city, are not parties to anything to do with that new assessment. It's starting from scratch.
I think it was developed in response to the court case. It's a new assessment for the years that are in here, and from my understanding from Mr. Levesque today, it was the alternative to or produced in conjunction or as an alternative to an audit that they had agreed to do.
That sounds right. I mean, from what I've been told.
That they've created this new assessment as almost a attempt to settle the other case, or
Or
I
a
think it's-
substitute. They would rather have the case, the appeal, so to speak, the remand
over the new
over
assessment.
the new assessment than.
Right. And so you could call it a revised assessment. I mean, we know one thing for sure. We know that there's like $13,000 that was taken off the assessment. And somebody discovered
that the court, that's in the court opinion says
Right.
that.
That happened over the last year.
13,000.
You want?
I remember that.
Yeah. So we know that the assessment that was passed by the Assembly is not the same. It had been changed already a little bit.
Does the Assembly have to reapprove this changed assessment, or is it so minor that it's
Well,
considered
that's where
just a?
I
Amy's question
think,
comes in.
I seem to recall doing it.
Yeah, and so that's.
My memory's not
why-
always the best, but I seem to
Right,
recall
but
doing it.
I think that that's.
And I
Can you confirm
That's
that?
accurate.
Can anybody confirm that? Or should we go to the clerk?
You
Well,
think
we'll
you
need
can-
we'll need to go to the clerk because I would rather not trust my memory. But I seem to remember that because I had questions when the assessment district, when it came back up, and I seem to remember saying basically they found a mathematical error or an error. So I think that change did come to the Assembly in the last year.
And was approved. So that it's possible that this mysterious new assessment has been approved by Assembly already.
That I don't know. And that's what, because this all just came up so recently, and
This was, he went to the meeting like last Wednesday or something.
And so I
I'm-
talked to Julia and I talked to the clerk, and they're kind of going, we haven't seen a new assessment.
Well, I seem to recall, and of
Well,
course.
because it was an April 4th, I'm sorry.
No.
But they said that it was April, Staley said, I got it April 4th of this year. So I'm talking about, do we see an
This year?
April 4th assessment? That's what
Yeah,
he
this
said.
year.
Just since this whole thing started, Joe went to the status hearing on the companion case, and then Staley confirmed that on April 4th I received the new assessment. And so, even if the Assembly passed a revised assessment, the question is that the same one as what he got? And so my problem is that he's getting things that the Assembly the record is being expanded here by operation of the parties, so that even if something came up there, but
When do you expect, Joe, to have Mr. Owen's response to Mr. Staley's letter?
He said he's working on the letter in response to Mike Staley's letter, and he hopes to have it to us today.
Today. We are in, is this the 15th, are we in the 15-day window right now between now and?
I think it starts, I think today was the day that she wanted to get the notices out,
Okay.
she being Barbara.
And this, actually, she's given us a copy of the letter. You have it in your, that is going out today, that's what she told me. You probably saw this yesterday.
I sure did, thank you.
So I anticipate this will go out today.
And Barbara and I talked about that
Mhm.
because of how convoluted this all is, and it seems to be, we're chasing rabbits right now, to some extent.
Well, exactly.
And she said, look, I want to get it out just so that I can preserve, the time. And if it's continued and I have to do it again, so be it.
I think that's the wise route. The other thing I would just like to comment on, my recollection of basically reaffirming this assessment. I have not gone and searched any records to refresh myself, so I'm not going to do that. But I really do think that we've taken it up in the last year. So if that were the case, what impact does that have on this? Or
I'm thinking from what I'm hearing, Amy, is that when the court made an adjustment, that adjustment might have gone in front of the assembly. But what they're calling the new assessment or revised assessment, whatever it is, I don't know what all's changed.
And that might be what I'm thinking about, is a court adjustment that came
Yeah.
back to us. I think that's exactly what I'm thinking about.
Yeah, so I don't think that really impacts
Why
this.
would they wait an entire year to give that to Staley on April 4th?
Well, if it came before us, it would be public record. He could have gotten it.
But why would you call that a new assessment?
So I think we definitely need clarification. I think you're right in that we should wait for Mr. Owen's comments, and then we need to decide how we're going to deal with this procedure on May 7th and 8th, if we in fact are going to go forward. But it appears we need to know if we in fact have an assessment that's come before the assembly, because if we haven't, it is like putting the cart before the horse. Wouldn't you agree?
Well, I can find out. I mean, I can go through and see in the records about an alternative assessment. But Amy, what I'm not going to know is whether what you passed is what was given.
Oh, I
to
understand
you.
what you're saying.
And so, and if we don't have
And that's
that
why-
connection,
Yeah.
then I don't know.
Well, we
what it is.
can direct Mr. Staley or ask Mr. Staley if he'll present that to Joe, so you can look at it.
Well, it was given to him by the Muni, so I think that the Muni should be able to forward that.
Oh, I'm sure they can. I'm not going to get into an investigative role, though.
Right.
So that's why I'm
Right.
trying to
No,
keep
that's right.
and
No,
direct
right.
all information
Procedure
to
only.
you. Yeah.
Yeah.
So what Staley says on, looks like page 3 of a 4-page letter, on the bottom is, as he's complaining about the audit and not getting things and due process, he says that it's important to note that the municipality took 2 years to compile and review its own records to come up with the original assessment amounts, which turned out to be erroneous. It then took the municipality more than another year to again review and audit the records to come up with the new assessments. And keep in mind that these are the municipality's own records that it's reviewing. So he says he actually has like 10 banker boxes full of documents, which I'm assuming are the new assessment in all the attachments.
Well, I would say from the Assembly's perspective, the task at hand is a task for our council in this matter to determine if in fact we have, I don't want to use the word right, but if we have an assessment that's ready for a hearing to be evaluated by the Assembly on May 7th.
I don't think we do.
Would you concur that's the question?
Yeah.
Okay. You
And-
think?
We're there right now.
What am I
That's,
missing?
no, the only other part I would have is that if there is to be a hearing on May 7th or 8th, that would indicate that it's part of more or less an appeal.
Correct.
And the reasons that the Superior Court gave for sending it back did they include not having, not allowing testimony from others that were beyond the plaintiff class?
I believe,
No, in fact, the decision in the case from the court is not clear, because throughout the decision, the court uses the term property owners, which is not defined to be the appellants, and so there's definitely a question there when you read the opinion, because if all property owners are affected and we only have 9 plaintiffs, then what do you do about that? And because we thought it was an appeal, when prior counsel looked at it and it looked like it was an appeal, the rationale was containment. Because otherwise, if you're appealing the assessment, if it's original assessment, other people had an opportunity to testify. If you keep opening it, and then they don't like it, and then it keeps getting appealed, and then you just have a never-ending thing. So the procedures that were drafted to date, which were only a couple and were approved by the Assembly, said that only appellants would testify. The record would not be enlarged. Here's what the court gave as the record. End. And this is what we're appealing. But when Joe went to the status hearing, he took away a completely different picture than.
But even if it's not a new assessment, does our procedures, do they cover the due process concerns that the court expressed?
the court found that they did.
Okay.
And that's why he remanded it back. He said it looks like the Assembly can, it has a section where it can do exactly what it needs to do.
Okay.
Right, and so what the court relied on there was the administrative procedures under 3.60, which leave a lot for the body to actually decide itself. And so the court hasn't ruled on the things that we decided so far, because that would have to go
Sure.
back. But Mr. Owens, the municipal attorney, early on took issue with not having enough process himself
I read that.
So
in
what-
this, and thought that some other things applied. Our independent counsel said, no, this is an administrative hearing. It's not this thing over here, and here are the dates.
And a lot of this is if you look at his letter and you look at the attachments, he didn't come to the Assembly first to ask for a continuance. He went first to the court, and the court said, look, I'm the appellate court. Don't have me, mess with this. Basically go to the Assembly, if you want to do things, and then I'll look at it as an appellate judge. But what Staley says on page 3 of 5 of his affidavit, he says on number 5, after he talks a lot about what's going on and how fast this all happened while it went slow at other times. The Assembly set the time for the rehearing on the assessments, as well as the procedures to be employed without input from counsel. So he's saying that whatever the Assembly did as far as the procedures, he was not involved. And the time set was not convenient for appellant's counsel because of previous commitments. Moreover, the procedure appears to be based on the erroneous assumption that the Assembly is hearing an appeal of the previous assessments as opposed to the new assessments. The Assembly has not allowed for lot owners other than the appellants to participate, despite the fact that the municipality intends to present new assessment rolls which will impact their property. Even the appellee informed the Assembly that it believes this is improper, and that was Bob Owens. Further, the Assembly has stated that the record is closed despite the fact that the municipality will present new assessment rolls, and despite the fact that this court previously held that the appellants were not given a meaningful right to participate in the previous hearings wherein the record was created. So that was their due process.
Yeah, they weren't given a meaningful ability to participate last time.
They didn't have the record. They kept demanding
Okay.
that they get this record, and it's like 4,000 pages. They didn't get it.
And when they did get it, it wasn't indexed, so it wasn't in chronological order, it was all shifted. So one of the court orders here was that they were to be, the muni was to give them
Yeah,
an
index.
indexed order.
And they have an index, but he's not satisfied with it, but I understand it.
Right, but the
Might
court
be-
didn't address that in this last motion practice, Julie, so I don't know where that stands.
I just have a side question, and Mr. Trainee might be the best one to answer this. But isn't it my understanding that when the new special assessment district was created, it went to the vote of the people? So,
It should have.
so
but
technically speaking, every landowner in that area who lives in that district had an opportunity to vote whether they wanted the special assessment or they didn't.
If
so-
they don't get the votes, it doesn't go forward.
Yeah, they had 57% of the vote, and then there was a delay, and they changed the project to add that lift station or whatever, and then like 70% of the people said, don't go forward with this, and that's a big issue.
Yeah.
It is, it's another issue that's out there.
See, I forgot.
So he continues to say that essentially the Assembly's procedure ignores this court's order that would permit appellants to present evidence. The Assembly's procedures do not permit appellants to present evidence, allowing only for argument based upon evidence already in the record. Well, that's the appeal part, and he's
Mhm.
going, this isn't an appeal. So what they want, and we can sort some of this out as far as we have to figure out what to do with the new assessment. But if the new assessment is just going to be presented to the Assembly at this hearing, I mean, I don't know if that's what the attorneys are thinking. And I'll sort that out and give you guys some recommendations and advice, and then you can go to the chair and decide how you want to proceed. If that's what they're talking about, then we just need to, if this is continued, we just need to find some dates, and we need to find out how many lot owners there are, because 2 days may not be enough.
Well, if we do another hearing on this thing and it's expanded, I want to see if we have to let all the people that own property on that come and testify.
Yeah.
If we're gonna restrict it to just the appellants, that doesn't work.
Well-
Because the old assessment did that, but if there's a new assessment, I wanna know what was the vote on the new assessment.
Right, and I just have to let you know, Mr. Trainee, that when Bob Owens sent an email yesterday, just kind of trying to give us a thumbnail sketch of what his arguments were, he says opportunity to speak, like the question of notice, anyone with an interest in these proceedings should be allowed to speak. So he also thinks that they should all be given notice. So any property owner whose
Clerk
property.
can do that with just a notice in the newspaper, general circulation. Because how could you possibly send to anybody that might have concern about it, even if they're not a property owner?
The utility company has a listing of all the properties that are affected. So
But
we have a
if-
list.
If they're saying you have to give it to more people than the property owners,
Right, no, it would be property owners. I may have stated
those
that
we can
wrong.
identify.
Yeah,
Bill, did you have a comment?
it's gonna be both, though. It's going to be by a letter to each of the lot owners, and then it's also gonna be on the website that the municipality has. It'll be on there for quite a while, and then it will also be in the newspaper.
Who are what's the scope of who's gonna get this letter?
If that letter went out, that would go to the appellants.
Only?
That's who that
That's
is.
who it's listed.
No,
listed on
this
here?
just says dear property owner, and it gives the list of appellants. The way that Cheryl Brooking created these notices,
Mhm.
and my understanding is that there's that everybody in the assessment district,
Mhm.
whether they're an appellant or not, that our code says they have to get a mailed notice. That's that 15-day notice. And so what Cheryl did for Barbara was to say, okay, all these people out there are gonna get the notice,
Mhm.
but we're telling them right here who is gonna be allowed to testify.
Yeah.
And so this is not the list that Cheryl intended for Barbara to send the list to.
But Barbara had no other list. So I
Right,
don't know if
because
Cheryl gave her another list.
No, Cheryl suggested that she get that list
Right.
from AWU. That was
Yeah.
that note that I sent back to you.
Right.
Cheryl, my understanding is Cheryl I wasn't present for that conversation,
Right.
but Cheryl reported back to me and she gave an email and said,
Yeah.
these are the procedures.
Right.
And so that's why, when we reviewed this notice,
hang
And so
on.
I didn't know if it
One
was
second.
everybody within 500 people or what it was.
Well, we have to figure that out.
One second. I want to go back to Bill, because I think on the previous topic, he had a comment.
It's just, it's not, it's more of just a real basic question. The administrative code, does it contain a provision for the assembly creating special assessments and a process for appealing them? Is that in the code?
That's not in 360. 360 is an administrative adjudication. There is code under Title 28 or something, is a whole process about creating special assessments.
Okay.
We use it for everything from water to sewer to roads. And you can't, if you don't have 50% of it, you can't do it.
And
Right.
it also even has a section that says if an assessment is remanded by the court, then you have to do these other things.
But 50% you're talking about is creating the district. It's not the actual assessment, because that usually comes later. The dollar amount comes
Create a
later.
district, and then
Right.
about AWU would go through and figure out what the assessment is, and they bring it into us.
Right.
But the homeowners would know how big of an assessment we're dealing with. Because I've seen them say, I can't pay that kind of money.
So in the court's order, he actually identifies the municipal code sections that he believes allows the assembly to have the type of hearing that's needed, so.
My only concern was is if in fact there's a new assessment, that we not combine, not try to get, if it is a new assessment and it's not just a revision, the old one or whatever that would mean, that whatever process goes forward doesn't try to combine the two, because it seems like that there should be a public hearing on an assessment for those
You're
affected.
right, though, because you gotta separate the
You
two.
know, and that I just want to make sure we don't fall into that if we discover that there is in
It's good to
fact a
have
new
an attorney on
assessment.
the body.
Yeah.
Well, and
I
that
know, right?
was my previous point. Well, I didn't know what Mike and Bob have in mind as far as this new assessment, because I'm surprised as everybody, if there's a new assessment, why doesn't anybody know about it?
Well, exactly. So I think we go back to our number one question. Is there an assessment that's ready for the assembly consideration on May 7th? I think that's step number one.
Well, I don't know. I mean, I don't think it would be May 7th, because I think if there is an assessment, it's a regular assembly thing,
Well,
not a hearing.
My point is it something we've already done?
If your memory's right, we already did it a year ago.
Mhm.
And I want to see what we did, get the minutes, and take a look at what the body passed in the discussion.
And I think Joe nailed it, though. I think it might have been something that the court said, no, you can't with this 13,000 or whatever it was. But we need to know if that is going to be part of this discussion,
Yeah.
or if we have a totally new assessment, then I think you make sure the two stay severed. That new assessment goes into the hopper, and
Goes through the process.
exactly.
If it helps at all, the 13,000 was related to landscaping. So there were some landscaping costs that were done that really didn't benefit the lot owners.
Well, and the only reason I say that I'm fairly certain that we had something was because it was the first time I had read about lift stations.
Mhm.
In no context in my life would I have ever read about. So that's why I say there's something. I don't remember exactly what it was. I'm not going to go investigate what it is. But, I think what we should do at this point, because I think we could, dog chasing the tail all afternoon. I think we need an answer from you as to, is there something that we really should be considering at the hearing that we have scheduled? I think Barbara is right. I mean, you had the discussion with her yesterday.
Mhm.
Just to keep us on track, let this notice go out.
Mhm.
I know it sounds like there's some discussion of who it's going out to, but you were comfortable yesterday after your meeting with her?
Right, and what we received was all of these property owners and
Is she
those.
going to send them out to those property owners
Yeah.
too?
Yes. That's
Right,
my
so it's not
understanding.
just going to be these 7.
No.
No, because she has a new list now. So it'll go out to, this notice will go out to that
Assessment.
bigger
Correct.
field
Correct.
of all those people. And then if it's changed, then you can send it out first class mail to all those people. Yeah,
So
not that big a deal.
is the committee then in agreement that, number one, we'll have Joe look and reevaluate, he can talk to counsel, whatever he needs to do to let us know if there's something we will actually have ready for consideration on the 7th.
I want to see if there's a new assessment out there.
Sure, but keeping, yeah, exactly, well, that'll
He
be part
has
of the
to-
discussion,
he
but.
has to do, remember that, and then Joe, you have to figure out how that line is. One of the things that Cheryl pointed out, and that's why Amy's so sensitive to it, is how much, going back and reviewing an investigation that you do. So I think that you find out yes or no through Joe whether there was an assessment, and then you'll have to decide if they can look at it, if this group right here can look at it beforehand, because
Yeah.
you want to.
If Joe
I
can
would
find
say
out
no.
if the first one was set aside
I
by
would say
somebody in
no.
the city, I'd like you to tell us who set it aside.
Okay.
Because if somebody passed it,
Yeah.
the mayor didn't veto it, it should have to
So
come back
that-
to us for us to set it aside.
That'll be part of it. So we'll have
Yeah.
the answer to that. I had a second question and I lost it. I had a point, I really did. So is there a question? You'll talk to the town. We'll get Bob Owen's letter today, and you'll evaluate that. So I guess what I would like to do is I would like to let you have the opportunity to kind of do your review of, talk to both attorneys, whatever you need to do, and look at the record to see what we did, if in fact we have something, and then get back together so we can advise the chairman if we're going to move forward or if we're not going to move forward. But obviously the notices will go out today, which will preserve the opportunity to move forward.
Yes,
Does that sound logical?
that sounds.
How long will it take you you'll get Bob's letter today, how long will it take you, or when would the next opportunity be for us to get back together?
Right. Well, I can do it this week if we get the letter and we need to meet and talk about it. I can tell you that we really need to look at the letter before we make a decision about the continuance, and the answer to these questions will also help.
Guide us in that
Guide us.
direction.
Didn't Bob Owen give some other dates?
We did.
And so, I guess my question just, and I'm neither an assembly member nor the council on this matter, but my question is, what is so compelling about keeping these dates when we don't know
Why is
what's
those
going
first
on?
and second
Why are you
dates so
sending
much?
out people notice
Well,
something that the group here doesn't even know?
This is just my perspective of when the chairman picked these dates. When you had the entire 11-member body together, people were very passionate about when they could and couldn't do it.
Well, not all
And-
of them for the 7th and 8th, Amy.
Not everybody was going to be here. We have 2 new
Nobody
members.
will be
Yes.
here.
Well, my point is this. This conversation is kind of moot at this point because we have to decide if we have anything to even hear on the 7th.
Right, but you're sending out notices.
Well, and I
whereas-
think I completely agree with Barbara on this one. I think we need to, because there has to be a reason for the continuance before we issue a continuance.
Well, one reason for the continuance, it seems to me, is that we don't have answers to these different questions.
Well, they are different, and that's exactly the reason why Joe is going to
And
find
I'm-
out if we, because my gut is going to tell me we're probably not going to have a hearing on the 7th, but I don't know because the information's not there yet.
I think, I sort of agree with Julia that based on the fact that just the uncertainty should be enough for us to continue the May 7th and 8th. And I wouldn't send out the notices to these people and then get everybody all fired up that there's going to be something and then there's not. I think we have enough confusion in front of us and enough unanswered questions that it's probably best not to go forward on May 7th and 8th. The city doesn't seem to think it's on fire to do that. That would be my...
Yeah, one of the reasons that we, when Barbara and I talked yesterday and decided to go ahead and do that, was because Bob Owens, when I spoke to him and Mike Staley together, said that he would oppose a continuance.
But he's since changed that.
Well, we think so, but he hasn't said that in his email, and we haven't seen his letter.
We gave other dates, though.
But he gave other dates. What does he say
Yeah.
about that?
Here's what he says about the dates.
I didn't see that email.
So, oh, you didn't see this one?
I don't think so.
Oh, okay.
It just
So,
came out.
as for whether the assembly hearing should proceed or follow the Superior Court case, that's what he talks about. I would prefer to keep some momentum going. And he's concerned about losing interest and use of its money, and so he wants everybody to proceed with deliberate speed. For what it's worth, I understand the assembly is meeting on June 10th, June 24th. Mr. Staley's in trial in July. The next meetings are August 5th and 19th, September 9th and 23rd. In the end, we want these assessment rolls to be done right. So that's all he says.
He
To me,
doesn't-
sounds like he's giving other dates, so.
He's giving other dates.
I think
and-
it's premature to say Mr. Owens is going to say one thing or another because we don't have his letter yet. I mean, it sounds sweet. Logically, I will bet you
And what day do those have to go out to comply with?
Today.
Today. And so, but if it wasn't on the 7th and 8th, and a major continuance wasn't, required, I mean, I guess my concern is that we have this whole scope of people that are gonna get a notice, and then, and then they're gonna get another notice, and that just adds to another.
Well, I think it's a
level of
legitimate
thing.
concern. And when I read his email, I still was left wondering, if he just is taking it for granted that the assembly's gonna continue this, or does he really still have an objection?
But why did he say that he thought that there could be the 15 days might not be enough?
I don't know. You read this, right?
Right, and
You
so
read the
I
whole thing?
read that to.
Who drives the train on this anyway? Is it, is it,
Chairman.
yeah, Bob, or is it the assembly that?
The assembly
Yeah.
drives
Assembly,
the
it's
train.
not Bob.
Yeah.
Bob
So-
works for us.
So, what?
He doesn't work for the assembly, he
No,
works
he works for the city of Anchorage.
He's
But setting the
representing the
date of
city
this,
here.
I mean, it should be a date that the assembly is comfortable with, not whether
So,
Bob is or
we
not.
could
Right,
call,
and so the two,
we could call Barbara in
right.
and find out where she's at on that. Number one.
She
Could be
told-
gone.
she told me
Has cleared-
she can't attend this meeting. She's too busy. She has something else.
Right.
Has May 7th and 8th been cleared with the two new assembly members?
Yeah, they
as-
told us
as
about it
a-
in our orientation.
As availability, and then I know that at the time, when 7th and 8th was picked, Cheryl didn't recognize that Elliot wasn't gonna be here. I talked to Ernie today on a different matter, but, he said, just by the way, it wasn't gonna hurt his feelings if we didn't meet on his birthday.
It's not going to hurt my feelings if we don't either. But I feel like we're kind of losing the scope. I mean, we need to have a clear answer, I think, before we move forward.
Well, let me look and see if he's
But
sent his letter.
Does moving forward include
Phil,
sending out a
what's
notice
your
that we're
question?
having a
Well,
hearing?
we
We don't
can't
even know if
have,
there's
we
a new
can't,
assessment.
yeah, we can't have a hearing if we don't notice.
He did not.
So theoretically,
Right,
no
but should we
deadline,
notice
have
it?
whatever we want to have.
7th and
Yep.
8th.
You see what I mean?
It's completely.
It's the tail chasing the dog, or the dog chasing the tail. It's a challenge.
Yeah,
How-
if you're sure that you want to have a hearing on the 7th, or
Well, I will
if
know
it's
after.
available, if you are sure that the 7th and 8th are when you want to have a hearing, assuming that there's enough to be heard on, then you have to send the notice out today. My question is, the 7th and 8th were fairly arbitrary dates, and so even if you do have everything in there, are you so sure that you want it on the 7th and 8th that it's worth?
Well, see, and that's the part where I'm getting uncomfortable because I know the chair had talked to everybody and decided those were the dates. I don't know that they were arbitrary. I don't know how they picked them.
I think we need to deal with whether she's got these notices out, and if you all, if you want to recommend to the chair that she not send those notices out, then you should have him call Barbara and say, don't send them out.
I disagree. I think that we'll probably end up not having the hearing on the 7th and 8th, but if we make that decision today, I mean, we're making
Then you
it without
can't
all the
have it.
facts. We can't have it on the 7th or 8th. So I think, is it convenient that people are going to get multiple notices? No, but I'd rather over-notice
Yeah.
than take it off the table.
Yeah, when Barbara and I had this discussion yesterday.
But there's 3 of us on the subcommittee, so I could be outvoted.
She said yesterday, because
I'm not gonna vote. You may have a conflict of interest, but I'm not gonna vote you.
Oh.
I told her yesterday that,
I just-
if this is continued, that she'd end up sending them out again, and she said, I have no problem doing that.
But at that time, did she just think that it was to 7 people?
According to Joe, he said earlier, she had that list.
No, we got the list to her
No, we got the
later.
list today.
But I don't think the list mattered as much. She was just jubilant to receive a list. I mean, she was very
Yeah.
happy.
Okay, so I think, what are your thoughts? Are you okay with sending this out today?
Yeah, I if left to my own resources, I wouldn't, but I'm comfortable sending it out to preserve that date.
Okay, Dick?
Send it out.
Okay, I concur.
want to get the rest of the information from Joe.
Yeah, I concur,
Because I have a
so
lot of questions on this mess.
let's, if we can do this, let's do this. So the subcommittee agrees that the letter should be sent out today to preserve the opportunity for the date, May 7th. Joe, can you notify the clerk, and I'll call the chairman too and discuss it with him. And then also, public, we'll get those answers to what information or what items we have for consideration if we have a hearing the 7th and 8th. I know I didn't state that very well, but is that
Right,
okay?
'cause we're
And
preserving
then,
those dates.
Mr. Traney and Mr. Evans, are you both available on Thursday?
This Thursday?
Mm-hmm.
Yeah.
Yeah.
You're
Not from
retired,
9 to
right?
12, but other than that,
Not from 9 to 12.
not from 9 to 12.
Okay. Do you know your schedule?
No, I'm available most of the day, so go ahead and I can make it work.
See, you just had to pick 9 to 12. That's my best time. Are you available at 12 o'clock or 12:30?
12:30.
12:30. Bill, are you available 12:30?
Yeah.
All right, Joe, are you available 12:30?
Yes.
Okay, so let's say, well, I'll have Barbara renotice the meeting. We'll come back on April 24th at 12:30, Assembly Room, Conference Room 240, or Clerk's Conference Room. I don't know what this
I
is
think
called.
it's 240. Room
240, provided it's available on Thursday, and then hopefully we'll have the answer to question number 1, which is really the one driving the bus, I think.
Yes.
Okay, sounds good. Anything else?
Thank you.
Okay, meeting is adjourned.